Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of when you need a foreign bank and financial account lawyer. First of all, what is an FBAR lawyer, right? So anyone can call themselves an FBAR lawyer. You filed a single FBAR on someone's behalf, suddenly you're an expert, right? Basically, FBAR lawyers are board-certified tax law specialists, and these attorneys specialize exclusively in offshore account matters. FBAR, which is Foreign Bank and Financial Account Reporting, FinCEN Form 114, FATCA, Foreign Account Tax Compliance Act, PFICs, offshore compliance in general. When do you actually need an FBAR lawyer, right? It's going to be when it's time to represent somebody in a FBAR issue. So prior year unreported FBARs, or a penalty's been assessed, or it's being enforced, there's litigation, the government files a lawsuit, right? They're trying to enforce an FBAR penalty. That's when you need an FBAR lawyer. If it's your first year filing an FBAR, it may help you to consult with an FBAR lawyer in order to get the lay of the land. But if you're not out of compliance for prior years, then you don't need a lawyer. I mean, why would you need a lawyer? You didn't do anything wrong yet, right? You may want to talk to a tax professional to assist you with filing in your current year. And make sure that there was no reporting requirement in prior years. Sometimes people think they didn't have a reporting requirement in prior years, but they actually did. Here's a common example. Current year, someone inherits an account $200,000. In the past 10 years, they've had 7 accounts. Each of them had maybe $3,000, $4,000, or $5,000. None of those accounts were over $10,000, so the person assumes they didn't have to file, but in reality, an FBAR is filed when the person has an annual aggregate total in excess of $10,000. So just kind of food for thought. But primarily, if it's your first year of reporting, you probably don't need a lawyer. So why do you need an FBAR lawyer in prior years? Because the IRS is on a rampage in enforcement, and they're trying to put penalties against everybody, and the penalties are brutal. There's civil and criminal. Criminal is pretty rare. Most of the time, a criminal FBAR scenario involves something more than that. There's some anti-money laundering provisions, and it's some structuring and smurfing, and someone's doing money laundering, and somebody has offshore tax evasion going on, and as part of the piece of the pie is the FBAR. It's not because poor Sally has one account with $24,000 that she didn't report, and the IRS is going to come bang down her door, drag her away, and throw her in prison. It's not how it works. Okay. When it comes to civil penalties, there's willful and non-willful. Even not, you hear the term non-willful, you think, how bad could it be? Well, unfortunately, it could be pretty tough. It ranges from a warning letter in lieu of penalty all the way up to a $10,000 penalty per account per year. Some courts disagree with that when the governments try to enforce it. Some courts say, take a step back, U.S. government. It should be limited to one penalty per form, whether you have one account or 24 accounts on there. Conversely, other courts are like, no, it's you can get up to 50%, right? So essentially what happens is it's $10,000 per violation per year, up to 50%, because it can't exceed the willfulness penalty. And that brings us to the willfulness penalty. The willfulness penalty it's 50% or $100,000. Both of these penalties, the $100,000 for willful, the $10,000 for non-willful, is adjusted for inflation. But willful is brutal. It's 50% or $100,000 per year, whichever is higher. So essentially, that makes the $100,000 the floor or the minimal penalty amount. Something to keep in mind is the agents do have discretion to reduce the penalty. The values I just explained, those are the max values per year per violation, but that's the value that they typically penalize you. That's where it starts at, and then hopefully with your attorney, you work that amount down. If you miss the deadline in prior years and you haven't reported, be careful of some of the absurd fear-mongering and scaremongering you'll find online. Most of the time, it's pretty simple to get into compliance. The IRS developed various amnesty programs. And the Voluntary Disclosure Program, VDP, is for people who are willful. So it's not like the IRS wants to recommend prosecution to everyone who doesn't report their foreign accounts. They have a program designed specifically for people who can't certify under penalty of perjury that they're non-willful. if you try to pull a fast one on the IRS when it comes to FBAR penalties, they can try to, they could examine you, they can audit you, they could refer to the special agents. Those special agents can then refer it out for a criminal complaint, criminal prosecution. So if you haven't reported in prior years, don't do a quiet disclosure. Quiet disclosure means either reporting going forward without fixing the prior problem, or just not reporting at all, or mass reporting at one time, or just filing going forward. It's not worth it. Okay, hire an attorney that you believe in, and get the matter taken care of. Which brings us to the all too familiar, how do you hire an FBAR lawyer? Well, the easiest way to think about it is what not to do, right? You want a firm that does everything tax and legal in-house, all communications with you, with the IRS, preparing all the documents, all the tax stuff. Some firms just aren't qualified to do this. So what they do is they bait you in with some low upfront fee, and then they refer you out to a CPA to do the tax. They make up things like a Covell letter will cover tax preparation, which it doesn't. And then you find yourself in the same situation as the tens, if not more than 100 people at this point have reached out to us and tell us the same scenario. They hire an attorney, and that attorney charges a low upfront fee. That attorney shot them over to a CPA who they weren't impressed with anyway, right? Now that CPA is charging hourly. That CPA is not stuck under whatever, is not bound to whatever fee the attorney's charging, right? So the attorney baits you in with the low fee. The CPA starts jacking up their fees. Then you go back to the attorney. He or she is now jacking up their fees, and you end up paying double essentially, okay? Because in order for the CPA to do it, they're charging a lot more. They didn't realize how complicated it was. The attorney you first went to is probably not a specialist, doesn't really know what they're doing, and now they're billing you hourly for stuff that you shouldn't be billed for. That's why everything should be flat fee. Always avoid going only to an accountant to do it, because then there's no attorney-client privilege. We have lots of free information available on our main website, goldinglawyers.com. If you think it's appropriate, you could reach out and schedule a reduced fee initial consultation. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.